Hello, everyone, and happy Halloween. Welcome to today's webinar presentation, Politics in the Office, Infinitely Spookier Than Halloween. The only thing scarier than a haunted house is the workplace during election season. With today's headlines dominated by controversial hot topics, people often turn to social media to share their perspective. But what do employers do if these discussions create a hostile work environment? Today, Brad, Alicia, and James will discuss the risks of politics and social media and what employers can do to mitigate these issues. Before getting further into today's topic, I would like to take a moment to introduce myself and my organization. My name is Stephanie Zielinski, and I'm the Marketing Director of ComplianceHR. To prevent a few popular questions from entering the Q&A box today, I'd like to let you all know this presentation will be recorded and everyone will receive an email for this event. Now, a bit about ComplianceHR for anyone who may be unfamiliar. ComplianceHR is a joint venture between two incredible and innovative organizations, the AI technology company Neota and the law firm Miller Mendelsohn. ComplianceHR delivers expert employment law guidance in a fraction of the time using traditional methods. Our goal is to simplify the complexity of employment law, something we will learn a lot about during today's presentation. Today, I would like to introduce you to two of our most popular solutions, PolicySmart and Reference Center. PolicySmart is a comprehensive handbook solution that provides you with federal and state compliant templates, compliance policy timelines, handbook checklists, and even automated emails to alert you on new legal changes as they go into effect. The Reference Center is a solution created to help you and your team quickly answer employment law and HR compliance questions. With information on a wide range of compliance topics, offering deep insights that bridge multiple compliance concerns, the Reference Center aims to help HR and legal professionals do their jobs more effectively and efficiently. If you're interested in learning more about the solutions, a survey should have popped up on your screen, though you may have to exit full screen mode to see it. If you'd like to sign up for a demo of the Navigator Suite, simply answer yes, and I will send your contact information to our team of experts who will have a deeper conversation with you about your compliance strategy and whether our tools can help you support it. In addition to a demonstration of our solutions, you may be eligible to receive a limited free trial of our products. If you're not sure at this time, I'll send the poll out once more before we conclude today's presentation, or you can request more information via the link on screen in the resources panel and of course on our website. I'll go ahead and conclude that poll. So again, you have multiple different ways to send in your request if you'd like once the poll is concluded. Now, we thought that it would be fun to kick today's presentation off before we announce the presenters. Brad, Alicia, and James have dressed up for Halloween. Excuse me, everyone. So you should see another poll on your screen. Please vote for which presenter's costume you like the best. We have Brad as Rachel Gunn, Elisha as the Jack-o'-lantern, and James as Chewbacca. All right, I will pass it over to you guys while we leave that poll open for everyone to vote.
No, thank you very much, Stephanie. And I am Brad Kelly in Littler's DC office, or today I'm specifically Ray Gunn, the Australian breakdancer from the Olympics. I have a very mean kangaroo hop that I've been practicing. And no, we're really excited to be here today to talk about these issues on Halloween. And well, we've got a bunch of jokes as well. The joke I'll start off with is, why didn't the skeleton go to prom? He had nobody to go with. Do you not find that joke very humorous? So we're going to try to have fun today, and feel free to make this as collaborative as possible. We'd love to answer any questions you have. But as I mentioned, I'm in the DC office of Littler Mendelsohn, and I'm a core member of Littler's Workplace Policy Institute, which is essentially the firm's government relations and advocacy arm. Before joining Littler a little over a year ago, I was a senior counsel at the U.S. Equal Employment Opportunity Commission, where I was very involved with the EOC's AI initiative and a bunch of the guidance documents that came out. Before joining the EOC, I worked at the U.S. Department of Labor's Wage and Hour Division as a senior policy advisor. And back in the day, before becoming a lawyer, I was a U.S. Army infantry and intelligence officer, and I'm an Iraq War veteran. And I'll turn it over to Elijah for her introduction.
Well, thanks as well, folks, for having us. And I am, of course, the Great Pumpkin, but when I'm not, I am Elisha Asgar. I sit in Littler's Seattle office. I'm a shareholder and the litigator, but I'm also the co-chair of Littler's EEO and Diversity Practice Group. We are an international practice group of Littler attorneys. We are a deep bench of folks with various specialties, but we work in the equal employment opportunity and diversity, equity, and inclusion space. And so I like to think of us as a soup to nuts store, everything from ideation, implementation, and yes, when necessary, defense of your DE&I programs. Without further ado, I'll throw this over to James.
Good morning or afternoon, depending on where you are in the country. So I am Chewbacca, but unfortunately, I don't know how to do the plaintiff Chewbacca roar. But when I'm not Chewbacca, I'm here at the firm's Dallas office, practicing in all areas of labor and employment law, and happy to have you here this day on Halloween. So look forward to it.
Well, and James is our official costume contest winner. So congratulations, James.
Congratulations. Oh, no. I love it. And James, you really must learn the roar. All right, folks. Congratulations to James. With that, let's dive into the meat and potatoes of our conversation today. We'll be starting off with the impacts of politics in the workplace. Really, I can't imagine a time when things have been more fraught for employers who find themselves at the crossroads of all these conversations, whether it is domestic politics, I see you next Tuesday, or international politics. And frankly, does the political season ever end any longer with not just the 24-hour news cycle, but also social media? It feels like our employees, our independent contractors, our interns, heck, even our customers remain in a continuous fraught. So we'll talk about that and its impact in the workplace. The legal landscape, of course, is where those two issues collide, because there are parameters that we need to be vigilant about while trying to maintain our workplace atmosphere, which trying to maintain that ethos of a collaborative environment hard when folks are so torn asunder by political issues. Some of the things we'll be talking about today are freedom of speech and expression at work. How do they play together? I will not give you the punchline quite yet. That will fall to my colleagues. But also there's state laws, right? There's federal laws, state laws, there's local ordinances, there's your policies, there's anti-discrimination concerns, and then James will talk to us about national labor relations board concerns, because never leave the NLRB out. There you go. Also, just so you can see how these parameters meet the real world, we'll give you some concrete real world examples, talk through some hypotheticals, and then Brad and I in particular never seem to have a single day pass without several phone calls floating around exactly the space of social media plus politics in the workplace or social justice in the workplace. And so based on our experience, we have formulated some FAQs, frequently asked questions, and time permitting, we'll dive into those as well. All right. Well, with that in mind, let's go to the next slide and get started on the idea of this growing incivility in the workplace, torn asunder, as I mentioned, by continuous, never-ending conversations, because the workday is no longer just 8 to 4 or 9 to 5 because of social media, because frankly of intranets, things such as Slack channels at work. Our colleagues are never silent. They're always speaking to each other. Here's some of that feedback we're getting based on the studies: 1.2 billion per day in reduced productivity due to uncivil behaviors at work. Average productivity loss of 31 minutes per occurrence. Folks, I won't read every single one of these bullets to you, but I'll tell you, every time an employer gets to the point where they pick up the phone and call outside counsel, gosh, that is already a significant amount of people hours lost and significant actual capital resources spent in unwrapping these tangled webs we are weaving on social media and in the workplace. And so, what extent is our organization concerned with managing divisive political and social beliefs among employees leading to the 2024 election just next week? Gosh, 40% of employers tell us moderately concerned, slightly concerned, those 38% bats in the night. The witches tell us it is not at all concerned, 13%, and the great pumpkin, 9%. My people there of the great pumpkin land, very, very concerned indeed. And sometimes this tends to be, in my in my experience, some of the more technologically savvy workplaces, folks who have a lot of intranet communications, they tend to fall in that 9% category. Okay, Brad, I will hand the baton over to you, but not until you listen to my very, very wonderful Halloweeny joke mixing with employment law. Tell me, Brad, why don't witches discuss politics at work? Because they
I don't know
know it'll
why.
just brew trouble. Okay, there you go. Onwards to you, Brad.
Oh, I like that. And I'll start off with a joke for this, for my part, which is, why are mummies good employees? They get wrapped up in their work.
Oh my goodness.
So to kind of piggyback on what Elijah was just discussing is why do we care about politics in the workplace? Elijah went through the impact that it has on productivity at work, the impact that it has on absenteeism, the fact that a lot of employees they look at political issues as something very deeply personal, something that's very connected. So what we see with a lot of the politics in the workplace is that it's not just about the election. That we've got an election in under a week from now, but we're seeing most of the client concerns dealing with the war in Gaza. We're seeing a lot of concerns with people posting on social media, whether it's criticism of Gaza or criticism of Israel or something along those lines. But you also have a bunch of other issues that are related to the election that can kind of come up in numerous cases that touch on a variety of different issues. So, for example, you have reproductive right issues, which touches on healthcare and touches on privacy and different ideas of personal rights and can be very deeply meaningful to employees. And you see that a lot of cases that a lot of these conversations about politics in the workplace can easily spill over into arguably discriminatory areas. On CNN this past weekend, there was a panel discussion about international events in the election. And then one of the panelists made a joke saying, "Oh, I hope your beeper doesn't go off." And there was immediate allegations that that was a racist or anti-Muslim joke. And CNN banned the commentator from coming back. But it just shows that even during a civil conversation, or what should be a civil conversation, it could easily become something that could turn into an EEO concern or an NLRB concern or something along those lines. So it's something that we have to be mindful of. But another area that we see a lot of concerns with from clients is what happens with an employee wants to come in wearing a hat. What if they're wearing a MAGA hat or want to put up a Harris poster or a Harris pin in their workplace or in their cubicle? This could obviously create a lot of problems. And this is why you need to be concerned about office politics and be concerned with what game plan do you have in place. What happens if an employee makes a post on LinkedIn about the war in Gaza, or what happens if one of these issues comes up? What is your game plan? And that's something we'll be discussing later on. Now, again, touching on the negative impacts of politics in the workplace, obviously political discussions or conflicts that start at the water cooler could really impact productivity. It could distract employees from their task and they're diverted away from debates or tensions with colleagues. You also see related to that employee focus, the fact that they're so prevalent, these political discussions, that employees may struggle to concentrate on their responsibilities and do their job. But it can also impact employee morale because it can polarize the workplace and lead to division among colleagues who have previously collaborated very well. And this can also contribute to an erosion of trust and weaken team cohesion, causing morale to drop and make many employees feel uncomfortable or unsupported. But it also has an impact on vendor relationships and customer service. because political tension can impact customer service when employees feel distracted and they're less able to engage positively with customers. Also, you see with many political issues in the workplace, it could lead to harassment complaints. We'll be talking about some of the more specific EEO issues, but political disagreements can lead to uncomfortable or hostile situations that escalate into harassment complaints. Again, the example from CNN this weekend about the so-called beeper joke, and something that was a joke to one person could be seen as offensive and could contribute to a hostile work environment. So it's really important that you're proactive here to make sure that employees don't feel targeted or marginalized based on their political views. And because this could lead to an increase in complaints, including complaints dealing with harassment concerns. Now, I think it's also important that it goes beyond just some of the legal concerns, that it's important to keep in mind that the politics in the workplace can also impact the employer's brand and reputation, which Elijah will be discussing later on. So you've got a whole host of concerns, as far as the legal and business concerns. But one of the biggest aspects about this coming election, less than a week away, is the impact of social media. Now, I do a lot of artificial intelligence law, so I advise a lot of clients on AI policies and different implications of when you're using an AI tool, of how to ensure that it's used in a legal and ethical way. But this is going to be the first election that's really impacted by artificial intelligence. And you see, even getting onto Twitter, or now known as X, you see a lot of memes that have been AI generated. You see a lot of videos that are AI generated of the candidates. And it's really interesting to think that historically, this will be the first presidential election really impacted by artificial intelligence. But when you add into the equation the impact of social media, it means that these digital platforms allow employees to reach very large groups in a more ready fashion. Social media also has a higher probability of being embarrassing and damaging to an employer's reputation. But I think more importantly for the concerns of a lot of our clients is that social media posts have the potential to go viral. This means that a simple post on LinkedIn or Facebook could go viral and reach a vast audience beyond the individual's direct network. And this increases the likelihood that the public or clients or potential partners may link the views that are expressed by that one employee to the views expressed by the company. So it's really important to keep that in mind as far as the impact of social media. So one of the issues we'll be discussing later today is, should you have a social media policy? Or if you do have a social media policy, how does that play into this? And this is particularly important with social media platforms like LinkedIn, where employees are directly linked to the company and it has the company's name along with the posts that they're making. So now we'll turn to the legal framework of these political concerns in the office. What are the laws that apply overall? And we'll walk through some of the higher level laws, and then we'll get into the EEO concerns as well as the National Labor Relations Act concerns. But to kind of set the baseline when it comes to politics in the office is, oftentimes we'll hear from employers, well, the employee says that we're violating their freedom of speech or freedom of expression at work. But this is largely inaccurate because the First Amendment generally only applies to government regulation and censorship speech. It does not apply to private employers from regulating political speech and expression at work. But given the fact that the First Amendment does not generally apply to the private workplace, we do have to be aware of statutory limitations on the ability for employers to restrict certain employee speech. And one example that James will be getting into greater detail later on is the National Labor Relations Act. And more recently, the NLRB has taken a very broad view of what is considered concerted protected activity. And that's something that to be mindful of. And then again, one of the themes you'll hear today is you have to be mindful of state and local laws, particularly in states like California, Connecticut. For example, Connecticut has basically applied the First Amendment rights to freedom of speech to private workplaces. And it's something to keep in mind that these state and local laws provide much greater protections. At the federal level, you do not have political discrimination as a protected class. That's not protected, by or enforced by the EOC, but certain states have provided political affiliation or political protections at the state or local level. And you see this in states, again, like California, in New York, and then local jurisdictions such as the District of Columbia. Now, I think one thing that's also important to flag, when it comes to politics in the office, is that what can employers do as far as contributions? And as a general rule, companies can spend as much money as they want to get involved in, to affect elections and to, make contributions. But the problem is that there is a big caveat to that, which is federal contractors. They're banned from making a contribution or promising to make a contribution to any political party or committee or any person for political office or use. And essentially, the purpose of this federal contractor ban is to prevent the idea that companies are essentially paying to play for government contracts. So it's to eliminate this idea of unfairness in how federal contracts are given out. So this is a very important thing, but this federal contractor ban does not apply to state and local elections. So that's another thing to keep in mind with contribution issues. Now, another important high-level aspect to keep in mind when it comes to politics in the workplace is that it is a federal crime if employers or any organization interferes with the ability to vote for federal candidates or to coerce in a way that affects voting. And likewise, it's a federal crime to bribe or compensate to vote in a certain way. And you don't hear about these laws being, you don't hear about these laws very often. But one thing that we advise clients on is to make sure that any sort of political activity they're involved in, it cannot be perceived in a way where they're interfering or coercing with the right to vote. So one issue with a politics in the workplace policy is that could that be viewed as a way of coercing or influencing the ways to vote? So it's just something to be mindful of, and it's something that I think it's important to flag. Now, again, when it comes to politics in the office, it's really essential to be mindful of state and local laws regulating political activity. Most of the political concerns that we see, dealing with the War in Gaza post or dealing with comments on different social justice issues, mainly impact state and local laws. So as I mentioned, at the federal level, political affiliation is not a protected class, but at the state level, including in California, in the District of Columbia, that is a protected political activity. So you can have different political protections that exist. Same with off-duty political activities like you have in the state of New York. So these are things to be mindful of. If there's different protections that exist for, off-duty lawful conduct, you have to take those into consideration.
Absolutely. And Brad, I'd say, remember, your city ordinances as well. For example, in the city of Seattle, we're looking at political ideology being a protected category. So really hypervigilance before you act in that space. And my practical advice always is to flag for your frontline folks before they engage in any kind of employment action, right? Go home and change your clothes, or you can't work today because of what you're wearing, or some such. When it even starts brushing up against issues such as which Brad is discussing, and politics in the workplace, it is absolutely something to reach out to legal or HR about before they proceed. Back to you, Brad.
No, thank you very much. And I think that's a really good point is, a lot of these get so complicated and they touch on so many different issues. And that's the issue. That's one of the key takeaways from our webinar today is that you have to be mindful of this in the multiple areas that this touches on. And, with that said, I'm going to turn it over to James to cover the National Labor Relations Act concerns.
Thanks, Brad. And so next we're going to touch upon how the National Labor Relations Act, which is enforced by the, I'm going to take this off briefly, it's hyperventilating in there, but how that bears on the politics in the workplace. It's a complex subject, and you might be thinking maybe you're in a non-unionized environment, and so this really doesn't apply to you. You might think of it as a galaxy far, far away, the National Labor Relations Board, but that's a common misconception. So both unionized and non-unionized environments, the NLRB has oversight and the National Labor Relations Act will apply. And what it does is it allows employees to engage in protected, concerted activities. So these are when non-supervisory employees come together for mutual aid and protection to improve their employment conditions outside of their employer and employee relationship. And so not all political discussions or advocacy are going to qualify for protection under the National Labor Relations Act, but some of them will. So what we're looking at is speech that has a close connection to an employment and involves the terms and conditions of employment under that employer's control may be protected under the National Labor Relations Act and thus subject to oversight by the board. So think about discrimination, affirmative action, diversity and inclusion programs, minimum wage issues, parental leave policies. I could go on. There's a lot of potential political issues that involve workplace rights. Even outside work, social media use, according to the NLRB, that can also be a form of protected activity so long as it meets the requirements of the National Labor Relations Act. So what we've seen is the current makeup of the board is inclined, as Brad mentioned previously, to interpret the scope of protected concerted activity very broadly within this framework, such that it might encompass advocacy for political and social causes, even though from the employer's perspective, they may have a tenuous connection to the workplace. This is also, it's important to note, an area where elections do have consequences because of the president's role in nominating and appointing people to be on the board. So the short-term future of the board is probably going to become clearer in the next few weeks, but we anticipate for at least the next few years that the makeup of the board is going to remain such that they are going to interpret the scope of protected concerted activity very broadly. And a related issue on that is captive audience bans. So over the last few years, there's been a growing movement to restrict employers from holding what are known as captive audience meetings. So this trend, gained momentum in April 2022 when the National Labor Relations Board General Counsel issued a memo which outlined her opinion that these meetings violate the National Labor Relations Act. And so the board has not adopted the General Counsel's view. The General Counsel is the prosecutorial and advocacy arm of the board, but does not make the decisions on behalf of the board. That's to simplify it. However, states have caught on, and now 10 states approximately have imposed bans that employers may not discriminate or take adverse actions against employees who refuse to attend these employer-sponsored meetings where the employer is discussing its own political, religious, social views on hot topics. And even this year alone, 5 states have enacted bans. So for instance, California just enacted a ban last month. It's scheduled to go into effect next year. And we're expecting that some business groups and other perhaps advocacy organizations are going to be bringing challenges to these laws in the courts. For instance, there's a lawsuit currently pending in Illinois at the moment where a think tank and a business group have sought injunctive relief to block the ban from going into effect, arguing that it encroaches on their First Amendment rights because this is government action, so the First Amendment would apply in that case. So because this is a trend, even though it's only in about 10 states, states like Connecticut, Hawaii, states who are usually on the the forefront of these sort of developments typically, but because it is a growing movement, this is something to keep an eye on because it could be coming to your state shortly. And with that, before I turn it back over to Elisha, I'm going to tell my Halloween joke, which was is what's the ghost's campaign pitch? What he says is finally, there's a candidate in this race who is transparent. We know that's a joke because we know politicians are not transparent, right? All right.
Thank you, James. I appreciate that. That is a good one. Before I move onwards with my next slide, I wanted to flag from the DEI perspective that captive audience bans are writ so large and writ so broadly that theoretically they could be misinterpreted or expansively interpreted to apply to your DEIB facilitated discussions, right? Where they cross with religious views or political beliefs, arguably, of your audiences. Similarly, if expansively interpreted, they might also implicate your DEIB training, unconscious bias, things of that nature. So again, I always tell employers when creating that training, think broadly and keep that antenna up. And of course, that might implicate employers with national footprints, even though these captive audience bans only find themselves in a smattering of states at this point. All right, onwards and upwards, we go to anti-discrimination concerns. Now, we talked about this a little bit. Cities such as Seattle, with their political ideology as a protected category, might come into play, and understand that political discussions and subjects might also be implicated. So really, oh my goodness, Brad, I see what's happening over there. Hard not to be distracted by a hippopotamus. In any case, here we go. Any kind of discussion, this is my gut check, right, folks? If you leave with nothing else, but you leave with a queasy feeling in your stomach, when you're thinking about places where political discussions start involving protected categories, whether that's political affiliations in certain jurisdictions, race, color, sex, gender identity, things of that nature, I would start bringing HR and or legal into the conversation. And this, for me, tends to be a place that is not only a place of tug of war between our employees, but also a space of some tug of war between federal agencies. For example, let me throw this example out and then invite Brad's insights from someone who was previously on the other side of this conversation. We have the National Labor Relations Board and the EEOC seemingly at loggerheads. For example, what happens if you have folks on a picket line loudly saying things such as, you're stealing our jobs, or these people are stealing our jobs, or build the wall, or something of that nature. Arguably, you might have employees who find that kind of rhetoric discriminatory or based on protected category, and the EEOC might hoist that flag. On the other hand, the NLRB might say, no, that is nothing but their protected concerted activity under Section 7. Brad, what say you?
Yeah, I think and also I did do a costume change. This is the year of Mudang, the hippo. So I did do a costume change, and if I combine the two, I become Raymu. So just something to consider. But no, I think Elijah, I think you covered that very well as far as the tension that exists between the NLRA and the EOC. And as we know that in the labor and employment world, that when there's a change in administration from Democrat to Republican or vice versa, there's a big ping pong effect. And you see this wide swings. And one of the problems has been, how do you reconcile, the EO concerns with the NLRA concerns? And, the example of somebody on a picket line who's yelling out, that build the wall, something that somebody could see as harassing, or it could be considered protected activity, depending on how you look at it. And we know that the EOC has had active discussions with the NLRB's general counsel on a joint enforcement memo. And this includes, we've heard that it was a 40-page document where it essentially meant that the EOC was going to defer to the NLRB general counsel on what is a protected concerted activity, and basically, say that, there's a strong chance that the NLRB position would prevail. And we have not heard any updates on that joint enforcement memo. It's, from what I've heard from some of my sources, it's kind of on hold for now. There hasn't been any updates, but it shows that there is an interest in trying to reconcile the concerns there. But there's still a lot of ambiguity. There's still a lot of gray area. So I think that's something that you really do need to seek legal counsel when it comes to certain issues. And I'll kick it back to Elijah for some of the other concerns.
Thank you, Raymu. Folks, for those who are saying that this is bringing some much needed levity to your day, you're welcome. And if you want to add some more, I strongly recommend Oscar Isaac on YouTube singing the hippopotamus song. Very funny indeed, but nothing funny about this next issue. Really a sea change in the way that we are assessing what might be a prima facie case for discrimination under Title VII. This, of course, this wave really started. Several cases in lower courts, but ultimately post SFFA versus Harvard and, of course, UNC, those two cases, albeit in the education space, not in the employment space, they had major ramifications for employers as well. For those who don't know, those were the cases in which the Supreme Court held that institutions of higher education, such as Harvard and UNC, may not take protected categories, and particularly race, as a factor into consideration when composing their freshman classes. That was a shot across the bow. Very shortly thereafter, if you recall, all those attorneys generals of various states on one side of the aisle, I shan't say which one, sending out a letter to all and sundry indicating that although SFFA, Harvard and UNC, were interpreted under Title VI, Title VII lives just next door. It is also a civil rights law, and under it, employers has never been allowed to take protected categories into consideration in making employment decisions. Thereafter, we saw some back and forth between different EEOC commissioners, but really what it did was to embolden members of the plaintiffs' bar as well as certain agencies, and we have seen that uptick, that resulting uptick in what was traditionally called reverse discrimination cases. But remember, folks, Title VII, writ large, right? Writ in large buckets. So all races protected, all national origins protected, so on and so forth. And therefore, discrimination against white and Caucasian individuals just as discriminatory as discrimination against Black or African American individuals. Hence, discrimination is discrimination. And we've seen a real uptick in that. Moving on from that, we have seen why, there you go, Muldrow versus City of St. Louis. That was an employment law case, and specifically, it made it far easier for plaintiffs to argue that they have reached the threshold of proving that prima facie case of discrimination under Title VII. Specifically, in Muldrow, you had a police sergeant who received a transfer. She went from a really plum assignment where she had FaceTime with the FBI, a car, other ephemeral benefits such as being allowed to drive a paid for vehicle and things of that nature, to having a transition to a job where she did not have those very same benefits. And of course, she was replaced by a male in her former position. She claimed that the transfer unto itself was discriminatory, even though there was no change in pay or change in position. And that was interesting because previously, folks like Brad, and I, and James, when we got our complaints on our desk, would have looked for that significant change, that tangible economic impact, that ultimate employment decision, in order to help us find that the plaintiff has articulated a claim for discrimination. No more, say, the Supremes. In fact, the Supreme Court of the United States said that now you just need some harm. And folks like Alito telling us we're not entirely sure what some harm is. Well, I agree with you, Alito. Neither do I. So as the lower courts battle out what that some harm standard means in order to establish a discrimination claim under Title VII, the implications for you and me and all the folks in the employment law world interpreting just where the parameters are on whether we can restrict speech of employees on social media, in the office, at the workplace, is so much more heightened, because now, at least as to discrimination under Title VII, we are working at this some harm standard. All right, so moving onwards to how do we then balance politics plus inclusion? Since 2020 in particular, we have been saying things to our employees such as bring your full self to work. But what if our employees' full selves are a little bit troublesome and in fact bump in nose first into the full selves of our other employees? And so what I would say to employers, as I speak practically to them, because ultimately, no matter what us with our legalese hats and our pumpkin hats on our heads say today, you really must live in the real world. And when you do, The rule of thumb I give to you is to take a step back from the message, right? Oh, whether someone is espousing Democratic ideals or Republican ideals or Green Party ideals or what have you, it doesn't really matter. Take a step back from the substance of the message and look at the categories of what is happening between the employees. Is it violence in the workplace? Is it solicitation? Is it a violation of your acceptable use policy? Is it a violation of your good old EEO policies? Ensure that when you act, regardless of the underlying message, you do so implementing those favorite words of every employment attorney: uniformity and consistency. And importantly, serve as a resource so that your frontline leaders know that they are not islands and they have resources available to them. Maybe that involves having proactive conversations with them. Really, to avoid these ideological conflicts, again, focus on those core principles. This is really what I want to boil down to. You can, even if you want to send out those statements, as many employers want to do, you can focus on saying things like no harassment, discrimination. Remember, folks, we have these EEO policies, acceptable use policies, violence in the workplace policies. It's okay to condemn hate and violence, regardless of which form it takes and from whence it comes. And it's okay to focus on telling our employees to engage in productive work environments and relationships without burning bridges, and ultimately ensure that you have employees aware of their EAP resources, etc., where they can come to seek support and feel psychologically safe when necessary. Okay, and remember, you want to take away certain strategic discussions. Remember to do that when people's amygdala is not all fired up and they're not in fight or flight, as sometimes they are in these spaces. Maybe come back the next shift, maybe come back later in the day. Listen first so you can understand where your employees are coming from. Remember, sometimes when the messaging can be particularly rife with concern, there is a tendency to want to act quickly. Remember to slow that down a little bit, bring in the necessary resources, think about the long game. At the end of the day, maybe you decide that termination is appropriate, but if you do, go into those kind of decisions eyes wide open with legal advice at your beck and call. Sometimes what that means is to have a plan in place. Hey, folks, if something really goes haywire, who are my first three people on my phone tree that I will call? Will I call legal? Will I call HR? Who will that be? Who will pick up that phone close to election day at midnight if things go haywire with regard to our company and social media posts, things of that nature? At all times, be respectful and decide how to respond and make appropriate preparations. That's something I just discussed. And remember that if you are deciding whether you are to say something on a hot topic that is just flooding the airwaves or not, your best touch point tends to be going back to the company's values. What is your company's mission? What is your company's business? What does your clientele expect? And that tends to be a good touch point for deciding if this is the day that you will speak on. I absolutely have employers who say that they are mission focused and will only make public statements when it is mission related. Otherwise, they do not partake in social commentary. And folks fall across the spectrum, but I think proactively understanding who you are, what your appetite is for risk, and where you are willing to go in this space allows you to engage in a much more conscious and thoughtful manner when the time does come. So you're not making that decision on the fly at 6 a.m. on a Sunday. Okay, folks, with that in mind, we're diving into the hypotheticals, our case studies. Let me read the very first one to you and then encourage you, Brad, James, and members of our audience to partake. Okay, Jimmy, our friend, a 40-year-old supervisor, talks to his 65-year-old friend and fellow Democrat and subordinate employee Sheila about the election during work and after work hours via text messages. Jimmy tells Sheila that he thinks that Joe Biden was too old to run for president. He makes related comments and sends Sheila memes about Biden's age. About Kamala Harris, Jimmy says, I don't think she has what it takes to run this country, but I'll vote for her because I don't have any option. And won't it be weird to have a first gentleman? Sheila does not respond to Jimmy's text comments. However, Sheila remembers every comment vividly in 2027 when she is involuntarily separated from employment by Jimmy for poor work performance. They bother her even more when she learns from her former colleague that Jimmy has hired a much younger male employee to fill her former role. Sheila files a lawsuit alleging, don't you know it, age and gender-based discrimination. As circumstantial evidence, she slaps Jimmy's own text messages as exhibits A through Z. Oh dear, folks, what do you think? What did Jimmy do wrong? What would you recommend differently for him? Brad, James, why don't you take a whack at this while our folks type diligently into the chat function?
I think that this is a type of example. I mean, as far as I think one question that's really important is if you have a scenario like this, what policy would you look to for, addressing this situation? I mean, would you immediately turn to the anti-discrimination policy, which is probably the answer here? And, I think especially for this example, if you take away the political aspects of it, if you take away the references to Harris or to Biden or the president, then is it any different than what you see with run-of-the-mill discrimination claims?
Absolutely. Just go down to the basics. Thanks, Brad. James, anything you'd like to add there?
I just think this illustrates that these comments are fairly common in private dialogue, and they demonstrate people's strongly held viewpoints on divisive issues. But when it gets into the workplace, it can take on a completely different tenor and have implications under the law for employers. And so while we think these might be somewhat innocuous, if bothersome comments in the private sphere, when they come into work, they can be cited as evidence of gender and age-based animus in a lawsuit and cause issues, which is why you have to go to the policies and address that at the time.
Absolutely. And folks, so proactively, what does this mean? We're not prohibiting our employees from being themselves and certainly speaking about political issues, because frankly, that is really, really hard to consistently and uniformly enforce, right? Speak of no politics in the workplace. Practically impossible, and bumps into those parameters that James previously flagged with regard to NLRA protections. However, I don't think it's a bad idea to proactively talk to your leaders, your supervisors, such as Jimmy, and say, hey, folks, and you're not pulling out any particular political party or the other, you're just giving your supervisors people management advice, right? And you're saying things like, hey, folks, remember, your none of your conversations are confidential, right? Anything can be subpoenaed subsequently during a lawsuit or even by an agency or some such. So be careful, friends. If you are a leader, understand that you have a higher mantle, a higher burden of responsibility upon your shoulders. Be more circumspect, be more self-aware about the conversations you have, whether it is physically or electronically with your coworkers and your colleagues, and particularly your subordinate employees. And although you will never prohibit this, my recommendation to most leaders is leaders, unless it's LinkedIn or some professional network of that nature, be thoughtful when you add your colleagues on Facebook or Snapchat or some of those more casual social media platforms. Why? Because you might be letting your hair down after hours and expressing your social and political beliefs. That might be implicated in a subsequent piece of litigation. All right, I am getting ready to throw this to Brad, but before I do, what's a pumpkin's favorite genre? Why, Pulp Fiction, of course. Onwards to you, Brad.
Oh, I like that one. All right, so now we're going to do another example. So this one's political discussions online. So Fatima, an Iraqi American and practicing Muslim, is an employee at a mid-sized company in Connecticut. She is known for her professionalism and dedication to her work. Recently, Fatima posted commentary on her personal LinkedIn profile about the ongoing Gaza-Israeli conflict. Upon noticing the post, the company's management became concerned. They worry that Fatima's public expression on such a sensitive and politically charged issue might attract unwanted attention or backlash, potentially affecting the company's reputation and client relationships. Management decides to request Fatima to remove her post, fearing that it could create a divisive atmosphere in the workplace and among clients. So I think this is a really good example of illustrating a number of comments, another of concerns that we see with politics in the workplace. I think starting out for one, Fatima, for at EEO purposes, there's a number of protected classes at issue here. There is, religion, there's race, there's ethnicity, and even if you kind of weigh in the state and local laws that might provide additional protections, there's a lot of different issues involved here. But I think one thing that's also important to flag when it comes to EEO concerns is that under Section 1981, which prohibits racial discrimination for contracting purposes, that provides that oftentimes that covers ethnic discrimination as well. So you see a lot of the DEI suits that we've seen in recent years where it's brought under Section 1981 instead of the Title VII because they don't want to go through the EEOC. They don't want to have to go through the agency process. So because of discrimination concerns that might arise under Section 1981, you need to be even more mindful. And Elijah brought up the example earlier of the Muldrow case and the impact that has for adverse action. And that's another thing to be mindful of. Things that had been historically considered not adverse actions may be considered adverse these days. Another issue here is the fact that this took place in Connecticut. As I mentioned earlier on, Connecticut has applied the freedom of speech protections that exist for the federal workplace into the private workplace. So how does that play into the scenario here? And the Connecticut law has a big exemption as far as if it substantially and materially impacts the working relationship and the employee relationship. But would this arise in those circumstances? How would this play into a law like Connecticut? So I think that those are all kind of issues that you need to be mindful of. And another thing to keep in mind here is that if the company tells Fatima to remove her post, then is that considered retaliation? Is Fatima able to say that is harassment from the employer, for protected activity? So I think that's another thing to be mindful of, the retaliation and harassment concerns and, the different issues that can arise across the board. And Elijah and James, do you have anything to add to this one?
No, I think you hit it all.
You got it, Brad.
And I think one other thing I do want to mention is that LinkedIn, the fact that this is posted on LinkedIn, and I do believe that LinkedIn is often for practical reasons viewed differently because it's viewed as a professional network. It's directly associated with the company. So I think that's another thing to be mindful of. I mean, if we get a call about politics in the workplace, I'm going to be much more aware of a LinkedIn post than I would be a TikTok video, even though going viral has the same type of risk. I'm sorry, James, you were going to add something?
Oh, well, one thing I could add, Brad, on this one was going back to Elisha's point of consistency and uniformity is certainly if the company is treating different viewpoints differently. So if somebody posts maybe, from the Israeli point of view, and if that's treated differently from the Palestinian point of view, then that's going to create issues for the company more so than if they had a uniform and consistent policy that was viewpoint neutral.
Yep. And one of the things I was looking, sorry, I know I said I had nothing, but here you go. This is why attorneys are dangerous, right? We can always find something. I have encountered the savvy poster who will post a diatribe, right, of whatever purpose, not just Fatima, but various other folks out there in the ether who might post their points of view. But a savvy poster will say something like, though I might be an employee of XYZ, this is purely my own opinion. And then you go back to your social media policy, friends, before you come down like a ton of bricks on that individual, because if your social media policy demands that sort of distancing, arguably they have a better stance because they did distinguish their opinions from that of the organization, and particularly if they don't cross-sell by having the organization's brand or logo or some such in that space. There you go. That's my 2 cents. Okay. Brad, if it's all the same with you, I am going to go down the road and talk about this one, political attire at the workplace. And I know this is top of minds for many folks in our audience because I see those questions, quite a few questions about hats and face masks and bandanas and the like. And so here we have a politically active, publicly traded company has made multiple statements in recent years related to its commitment to IE&D, recent events, and its position on proposed legislation. Recently, a complaint was submitted by an employee who alleged that a colleague was wearing a red MAGA hat at the worksite and stating her support for Israel. A year earlier, the company had provided its employees with hats featuring the Ukrainian flag. Now, I'm going to take a step away from the unique employment issues here to look at a meta issue, right? The bigger issue here is how might an employer be facing the public and branding itself if it simultaneously is taking vociferous stances on active political issues in the media sphere, for example, even with the members of its C-suite, perhaps visiting, active war zone and standing side to side with leaders of that country or some such, while simultaneously putting the end to conversations and political activity in their own workplace. When you take a step back from the employment space that we could talk about ad nauseum when it comes to this hypothetical, understand that this has brand implications and implications for how the public is going to be viewing your organization. And so, as a DEI consultant, in addition to being a litigator, I would flag that one of the concerns over here is to ensure that when your legal team is making a decision, it better be conversing with your marketing team and your DEI team so that all these organizational elements don't sit in separate silos, because the organization needs to have one personality publicly. Either it is a progressive organization that takes stances on political events du jour, or it does not, or it is best able to articulate when it does and it doesn't. Otherwise, this fractious multi-personality will be used against you in future litigation, where this employee might say, in fact, the only reason you came down on my wearing of the MAGA hat and my speaking of Israel like a ton of bricks was because you actively held animus against me because of my belongingness to certain communities, or perhaps these are proxies for certain communities. With that, I'll throw it to James for the final case study.
All right, final one here. I think we're running down on time, so I'll be quick. Angela decides she wants to serve her community, so she decides to run for a seat on the county board of directors. Before doing so, she checks with her company and confirms that they don't have an issue with her running for office. Good news, she wins. The bad news is she's so devoted to her role, she's spending more and more time away from work on her political duties, and her performance is beginning to slip. So the company looks into the issues, determines Angela is spending much less time on her job than she used to. This is creating errors in her work, and the company gives her an ultimatum. She can step down from the county board, or she can leave the company involuntarily. She brings a claim for political discrimination under California law. So we know California law has a prohibition on interfering with political activities of employees. And this is actually based on a real case that came out of California. There was a financial advisor who got elected to a seat on a county board, and that new position required them to dedicate 35 hours a week, including 25 hours during business hours, while they were also holding down a full-time job with this investment bank. And as in our hypothetical, this did not escape their employer's attention. Eventually, the company decided that the employee had a choice. They could resign from the county board, or they could be involuntarily terminated from the company. And so the employee was unwilling to give up their nascent political career and was terminated. And even though California has much more expansive protections than most states when it comes to political rights, the result actually was that the company won. The court found that the reason was apolitical and legitimate. That is, the employee could not possibly work 2 full-time jobs. And the nature of the second job, that it was a political office, was not the issue. The employee could have had another side hustle that took up 25 hours during the normal work week. That would also have been an issue for the company. And so they were not specifically targeting the employee because the job was political. The result may have been different, however, if another employee who had taken, let's say, a part-time job at a nonprofit for the same amount of time during the work week was allowed to do so because the company saw nonprofit work as more noble than the messy business of politics, or if the company was selective in how it treated such cases based on the employee's political affiliation. So bottom line here is that a neutral, apolitical reason can inoculate the company against action when an employee suggests they're doing it based on a political reason. And Elijah and Brad, anything to add there?
No, I think that sums it up well. I think that, oftentimes you've got concerns with California law, especially with political protections, but it shows that if there's a non-political reason, I think that's, kind of the key takeaway. I forgot to do my joke the last time, so I do want to say, why was the witch late for work? She overswept. But one thing I think for our takeaways from today, just wrapping it up, is the importance of having a policy and having that game plan in place. Be aware, do you have an anti-discrimination policy? What does your social media policy say when you've got scenarios that take up like this? And what happens if an employee says to you, I want to run for political office? Are you prepared to, for that scenario? What policies would apply? Elijah?
Absolutely. And I want to be very clear, folks, when we say policy, we don't really underscore the value of politics in the workplace policy. In fact, we are speaking of your good old EEO policies and all and sundry from your handbook that are the better way of ensuring that equal enforcement, right? You want to manage it just as you have in the past with regard to any other violence in the workplace issue. So equal enforcement, and what I leave you with is uniformity and consistency. James?
Yeah, and I think here we are at 101, so I'll just say thanks for joining us on Halloween, and have fun trick-or-treating.
Enjoy your candy,
Thanks, y'all.
folks. Thank you.
Bye.